Hi, my name is Attorney Walter Rudolph Hnot III, and I'm with Disability Resolution PA. We're going to be doing an attorney review of the following video: the secret to getting disability on the first try. Oh, I like that title. The secret to getting disability benefits on the first try, like SSDI benefits, SSI benefits, right? Not having to go through reconsideration, the administrative law judge hearings, appeals council, district circuit, Supreme Court, none of that jazz on the first try. First off, I give this video a solid B rating for a non-attorney. He genuinely wants to help people to obtain Social Security disability benefits. He genuinely wants these individuals to not have to go through the hell of waiting year after year to go in front of an administrative law judge to maybe be found disabled. So for that regard, I give it a solid B because he genuinely wants people to be found disabled. Let's go ahead and talk about some of the issues that are in this video. First off, his secret is simple. It's that he brought his medical documentation in when he applied for Social Security disability benefits with his 16 BK and 8,000 BK, submitted it all together, and poof, he was found disabled very quickly. His bringing his medical documentation in to be found disabled, and that being the reason that he was found disabled because he brought the medical evidence in, had absolutely nothing to do with whether or not he was going to be found disabled. He would have been found disabled de facto no matter what because he was a stage 4 heart failure situation. Those people are in the terminal, those people are in the CAL, compassionate allowance listing, those people are in the they're going to die if they don't get a transplant scenario. They're not in the mild, they're not in the moderate, they're not in the severe, they're in the extreme category. What do I mean by that? They're not in the mild, we don't care about the milds. Moderates, usually not that helpful. Severe, that's what you're usually found disabled for. Extreme, you're going to die soon. It has nothing to do with him bringing in his medical documentation right up front. It may have helped speed up the process because the SSA through DDS doesn't have to go buy them. But no matter what, he fell under the I-2-1-40 statute, which basically makes his entire situation an expedited claim at a very high level. What do I mean by that? The whole point of this video is to say he had a secret to teach you about getting found disabled right up front. First off, it's no secret. Every publication from the SSA and every other government agency within the U.S. publishes, when you're applying for this, whether it's an IRS situation or a SSA situation, whatever. It doesn't. When you're applying for something that you want to be part of some program, it's very simple. They always tell you the same thing. Collect all of your documentation. Therein lies, so there's no secret there. They always tell you, collect as much of your documentation as possible. Therein lies another issue. He talks about only medical evidence. Medical evidence is not the de facto definitive thing that gets you found disabled. It's not. Element 1 of the 5-step sequential process requires that you not be earning over SGA, substantial gainful activity. If you're earning over that amount per month, Google it. I'm not going to do it for you because I do that all the time and then you guys don't put any effort into this. Google it. What is 2019 SGA or whatever year you're in? If you're earning over that amount per month, then you're not eligible for disability benefits. Okay? Whatever medical evidence you have, you're not eligible. Now, there's ways around that with, okay, we had a failed work attempt or, we're trying a trial work thing. There's ways around that, sure. But for the majority of the time, if you're consistently earning over SGA, you're not going to be found disabled. You violate element 1. And I'll give you a quick summary as to what all the elements of the 5-step sequential process are so that you're not sitting there going, well, what do you mean there's elements to disability law? Of course there's elements to disability law. It's not just you show up with your medical evidence and poof, you're found disabled. Come on. Anyway, my point is this. Element 1, right? Can it be earning over SGA, substantial gainful activity? Element 2, your disability has to last 12 months or be terminal, so it's got to be severe. Element 3, you have to meet, equal, or exceed a listing. Imagine a giant, like from the ceiling to the ground list of disabling qualities, right? Disabling impairments. Find the ones that match up with you, and you have to be as bad as one, you have to be one, or you have to be worse than one, right? Or have medical equivalency, which is what the Supreme Court stated for one of those defined listings, okay? Then if you don't, for that one disability, meet, equal, or exceed one of those listings for that one disability, then we start to look at all of your disabilities. You know what I mean? Everything that's wrong with you, and will it cause you to have a work limitation? So let's go ahead and talk about that. What does that mean? That means that basically, when it comes down to your, I guess we lost a light there. When it comes down to, your ability to do things, think of like a football player or a basketball player or whatever, somebody who they do an RFC on. How far can they run? How far can they throw? How often can they do this thing? They do the disabled person's version of that. And what do I mean? They do a walking, standing, pushing, pulling, crouching, crawling, remembering, focusing, completing of instructions. How well can you do written instructions? How well can you do oral instructions? How well can you get along with others? Complete tasks on time. They do a disabled person's version of that. Now, why is that relevant? Why is that important? It's relevant and important for you because that's what gets you from element 3 to element 4. 4 and 5 are all about work. If you can't work in the national economy to the levels of SGA that they're looking for, then guess what? You'll be found disabled. Element 4, can you do your past relevant work? That's the work you did within the past 15 years. Element 5, can you do relevant transferable skilled work? That's where they take the skills, right, from your past work you did within the past 15 years, and they see if there's other jobs in the national economy that share those skills, that which they can draw from and say you might be able to do. If you can't do your past relevant work, if you can't do relevant transferable skilled work, element 5 is RTSW, relevant transferable skilled work and unskilled work. If you can't do RTSW and you can't do unskilled work, which is all element 5, unskilled work's like, blanching almonds or tying shoelaces into shoes or whatever. It's like the most basic jobs out there. They're SVP1s and SVP2s. If you're not sure what an SVP is, look up specific vocational preparations. That'll explain what that is. What they're looking to see is if you can work in the national economy. But you don't have to do element 4 and 5 if you meet element 3, which is the severe disability listing situation. This guy met even more than that. He was going to die. He was a transplant or death situation from what it looks like, from what it sounds like. So his secret to bring his medical evidence up front has nothing to do with the reason why he was found disabled. And the secret to bring your medical evidence to the SSA up front is no secret. They publish that in every single book that they create. So, all right. And I want to go back to the point. This is a guy who's genuinely trying to help you, and he's doing a good job, and I don't want to come down on him. I tend to, in my videos, be a little jaded and tired and beat up because right now it's a Saturday night, and I'm making these because I know there's a lot of people out there that are going, oh my God, what the hell do I do with my life? I'm about to become homeless, or I've been homeless for 2-3 years, and I don't know what to do. I'm tired of living in the woods. I'm trying to help you guys basically get to where you need to be to get through this process. I get called multiple times. It's about 5 or 6 times a day from people that are completely out of the state. I mean, like California, Hawaii, way out, or even out of the country. That's happening more and more often now. To ask about disability questions and how their program might be different from this program, and can they use this? They're trying to find tactics that are applicable. Anyway, the point is this. One thing that did irk me about this video is that he spent a lot of time saying how he didn't need an attorney, how he didn't use an attorney, how he went there alone to go ahead and file his documentation with the Social Security Administration, his medical documentation, and, basically he did this without an attorney. What irks me is that right in the beginning of the video, he talks about his good friend who he consulted with, who's a Social Security disability attorney, before even starting this entire process of what to do with it. And then the rest of the video, he goes on about how he didn't need an attorney. For all of you people out there that are not dying, right? Where they're not like, okay, in the next 6 months, in the next 12 months, you're going to die. Your situation is not this person's situation. Okay? There's no specific statute to expedite the entire situation that he went through like there is for you. There might be. You might be homeless, suicidal, homicidal, VPAT, 100% VPAT, which is VA-based disability benefits, where you've been found 100% disabled under the VA. You might be. There might be some caveat that you fit into, but most likely not. This guy was found disabled because he fit into, and so quickly, because he fit into a Cal and a Terry and an I-2-1-40 subsection A. The reason he fit into it was because he was so extremely disabled. He was going to die. That's about that. He had to have a transplant, or else it was going to be lights out. It has nothing to do with whether or not he had an attorney or didn't have an attorney. He was going to be found disabled no matter what, because there was no wiggle room. It was obvious. He wasn't moderate to severe. He wasn't just a bunch of moderates. He wasn't severe, but the medical evidence is weak. He was extreme. And Absolutely, the medical evidence was proof of it. It was simple. It was straightforward. The case never needed an attorney. It never needed an experienced SSA rep. It needed the earliest level SSA person to basically adjudicate it because it was simple. There are those claims out there. His was one of them. That's why this video can be a little misleading, because most of you, 99% of you, don't fit into the same category that he does. Okay. He makes another statement that wait, before we go into that, he talks about medical evidence. He brought all this medical evidence, right? And we talked about, the 5-step sequential process and the SGA. And if you're earning over SGA, you can't be found disabled. Ergo, if you don't have vocational evidence, job evidence, what you're earning evidence, it's not going to happen, right? Because you need to have that kind of evidence, or the SSA needs to obtain it from the IRS in the form of a detailed earnings query, summary earnings query, and sometimes they do a new hire query. Sometimes they get a few other queries in there. So you have to have other types of evidence. I mean, like vocational, academia, administrative, legal. There's all these different types of evidence. Medical is not the only type of evidence that you submit to win these claims. So please don't sit there and think, I just got to get my medical documents together, show up there with my initial filing documents, and boom, I'll be found disabled. That is terrible thinking. That is moronic thinking. That is going to literally cost you a lot of grief. And you'll be sitting there going, what? I did exactly what the video said. I did exactly what he said to do. That's not how it works. I'm sorry. That's just not how it works. But remember, this guy's trying to help. He's not an attorney, so with a grain of salt. He made a lot of great points in this video too, so watch it, check it out. It's really good and has some great stuff in it. There's another little thing that I saw in there that bugged me a little bit too. Under 40 equals standard procedure to deny all people. That's kind of what he was saying in there. It's the case. No, that's not the case. I have tons of claimants that basically go through when they're 36, when they're 42, when they're 48, whatever. The way it works is the law, every 5 years from 45 years up, 45 to a day before 50, 50 to a day before 55, 55 to a day before 60, 60 to a day before 65. Each 5 years, the statute changes, the law changes to go ahead and essentially make it easier to be found disabled by limiting the elements of the 5-step sequential process. So by the time you're at 60 years old, or you can negotiate a little bit at 59, when you get to that point, right, element 5 of the 5-step sequential process, they don't even use it. It doesn't even exist at that point. We don't care. We just want to know, can he do his past work? Because old dogs can't learn new tricks. So we just want to know if he can do his past work, not whether he can do other types of jobs in the national economy. I get people found disabled all the time that are in their 40s. The claims are harder. This is true. But once again, to a non-attorney, there's a lot of bright light, black versus white, not gray room law. And because of that, this is kind of what they come out with. People that are not attorneys go, oh, it's like this, because this is what I see all the time. And even then, how do you see this all the time? Do you have tons of clients that you work with? But that's another thing. Okay. Issue 7. He states that he never had to pay anything for his medical records. Okay. Let me walk you through how that works. Some doctors will submit their medical documentation to you for no fee. That is an extreme rarity, especially nowadays, because doctors are accustomed to what's called double dipping, which is where they charge you $150 to see you, and then they charge you $100 under the HIPAA law, $1 per page, to go ahead and obtain your medical documentation. So what do I mean by all this? It means that what you need to know from an attorney's standpoint, you need to know what directive letters are. Directive letters are unlike HIPAAs. HIPAAs, directive letters fall under HIPAA law, but HIPAAs are where you send out for paper records. You get back a stack of paper, it's $1 per page. 400 pages is $400 plus $25 to ship. Directive letters are where you are requesting the medical documentation in a digital form, whether it's a CD, a jump drive, that's a USB that you put in, or over the internet. You can download it securely, right? All these options. I see some people are already chatting me up about on YouTube about another video. So what I'm talking about here is you'll really end up at the end of the day paying around the digital version for directive letters around $6.50 as opposed to $425 for your medical records. Directive letters are really simple. I'm about to make a bunch of videos on them. If you want to know more about them, I'm the attorney in Florida. I'm the guy who literally spent 3 years fighting PSYOCs and other groups, having multiple apology letters, which for attorneys, just so you know, is the equivalent of having heads that are stuck on the wall. I have multiple apology letters from these groups because they broke federal law. They consistently broke federal law because they're losing massive amounts of money based upon this new law. They hate it. There's nothing they can do about it unless they try and change the law, which of course they'll try to do because they have millions and millions and millions already. So there will be a battle there. I'll be at the battleground. I'm sure you won't, but I'll make a video about it and you'll learn about it and you'll say, wow, that's really great that he did that. He spent so much of his time and his youth and his fun, doing that instead of on a Saturday night going out and having fun with friends like I'm doing right now while making this video. So let's talk about that. Cheapest way to get your records, directive letters, if they won't give them to you for free. And remember, when you request them for free, you're not actually usually getting what we need for SSA purposes for the adjudication process. You're getting like daily assessments and general upkeeps and warning label crap. We don't use that. We want machine outputs, tests. We want findings of the doctor, that's their analysis, and we want diagnostic impressions, bullet points of what's wrong with you. Bullet points of what's wrong with you, okay? Medical tests, analysis from the doctor, findings, diagnostic impressions. Okay, I've gone through the issues that I found with that video, so I just want to clear those up. Once again, I want to reiterate, this guy is genuinely trying to help you guys get your disability benefits up front. These are the issues that I found with his video. I'm going to be doing other videos where I review other people that are attorneys, where I found issues with what they stated, where I found law that's contradictory to what they stated. The next video I'm going to be doing is the top 8 ways to get approved for Social Security disability benefits. This is a Ginsburg video. I love Ginsburg videos. I think his voice is super soothing and super relaxing, but not as soft and not as nice as the voice of The Secret to Getting Disability on the First Try. His voice, it's like literally a country song on a midsummer night's, dreamy, sunset right as the sun goes. It's like not James Bond. It's like a Indiana Jones movie, just riding off on and his voice is narrated. It's just so nice and calm. But remember, why you guys like that video so much is because he's super relatable to you. The information is simple. He's coming across from his heart, and it makes sense because it's simple. But a lot of it wasn't right. And that's why I'm doing these reviews. And the other thing is, too, I used to go to the library a lot and basically give, seminars on how this stuff worked. And I would take all the things that people would tell me and that it was wrong about how they thought the system worked. Like only SSI is for, mental claims. Wrong. SSI and SSDI have the same medical standard for severity. I used to hear all these crazy things. I'm now doing that for some of these disability videos. And the purpose of it is to try and help you guys understand what he was getting at and what he meant, okay? If he were an attorney, he would mean something a little bit different. And by and through that, I want to make sure that you guys get that message. And actually, I'd love to work with him in the future because if I could give him some of my knowledge and information and he could help you with that, his voice is so calming. Like when I watched the video, the first time I watched it and listened to it, I was like, there's some issues in it, but whatever, And then I watched it a second time. I was like, wait a minute, there's a bunch of issues with it. We might need to do a video about like the things that I found that were problematic with it. But by and through that, here's what I really like about having him do videos. The difference between you and somebody who's been through it like him is this. And then the difference between him and me is up here. The gap between my knowledge and your knowledge is huge, right? If I'm saying, DLI, POF, whatever, all these little acronyms and things like that, and you're going, I don't understand what's going on, or if I'm citing a statute, a particular rule, you're going to be sitting going, what's going on? That's because, to me, when I talk to the judges aren't looking for me to go ahead and sit there and basically give them this, from the heart resuscitation of what's going on with the claim. No, they're going to want to, okay, this is a 12.04 depression/bipolar scenario where it meets, element 3 and 6 and da-da-da. The only problem, Your Honor, is with this particular issue, DLI is set. He's currently receiving this. We look good to go on these particular issues. We're shooting for essentially a protective filing date, or we could be shooting for retroactive benefits 17 months back from the initial actual alleged onset date, AOD. The judges don't want that voice. They just want a summary as to why they should approve it or not approve it. And they want a brief to read that makes it easy for them to approve. They want to be able to copy what's in the brief and put it into their brief if it makes sense. Okay? If it makes sense to them. So my point to you is this. I would like to see him make more videos, because frankly, the gap of knowledge is much smaller between you and him, and he's much more relatable than somebody like myself is, because when I attack this, it's not just black and white. There's the black and white law, and there's the gray area of how everybody practices it. That's tricky. Okay, so I tried to give you a quick annotated version of that video. I know you guys like this video. I know you guys, a lot of people have seen it. I saw the little, counter on it go way up. I'm going to be doing another video after this point, a review of a Ginsburg video. I love Ginsburg's videos. He's so relaxing. Stick around for that one. If you want to know what that one is, it's going to be called Top 8 Ways to Get Approved for Social Security Disability Attorney Review. I'm just going to put that at the end of it, attorney review. Okay, so it's an attorney reviewing an attorney. So I'm not just reviewing non-attorneys. I'm not just beating up on that guy. I'm also reviewing other attorneys who have made videos. Okay. My name is Attorney Walter Rudolph Hnot III. I'm a federal and state attorney for Social Security Disability Benefits. Orlando-based for the most part, Central Florida now, because we've grown and grown and grown. We have claimants all over the place. If you'd like a video made about a particular topic, that's fine. Shoot me an email and let me know. If you would like a particular question answered quickly, give me a call, shoot me an email. You can even shoot me a text now through the digital phone system for the business line. When it comes down to this, it might not be the most up-to-date information. So if you'd like the most up-to-date information, call me, email me, get a hold of me. All right? We'll go from there. And remember, when you leave things in the comments section, give me details. And if there are details that you're afraid to give out, just email them to me. WRH@disabilityresolution.com. That way there's no breach of attorney-client privilege there. All right? I'll catch you a little bit later. Have a wonderful day, and we'll go from there. Thanks so much. Bye-bye.